6 items you should consider including in your estate plan. A will. This is the main component of your estate plan and ensures your property is distributed according to your wishes. Durable power of attorney. This person will act on your behalf when you are unable to do so. Beneficiary designation. You want to decide your beneficiaries. If you don't, a judge might make that choice for you. Letter of intent. It's a document left to your executor or a beneficiary, and it defines what you want done with a particular asset after your death or incapacitation. Healthcare power of attorney. This will designate another individual to make important healthcare decisions on your behalf. Guardianship designations. If you have small children, you want to make sure you decide who will care for them if you no longer can. For more financial information, go to aarp.org/money.
Hello and welcome. My name is Sonia Gibbons-Reed, State and Community Engagement Analyst for AARP Illinois. AARP is a nonprofit and nonpartisan membership organization that's been working to promote the health and well-being of older Americans for more than 60 years. Today's virtual event is the third in a series of virtual offerings that takes a deeper dive into elder law. Many of our key questions being answered by our elder law attorney are ones submitted by you, the viewer, and we thank you for your interest and engagement on this important topic. By connecting you to resources on advanced planning that can eliminate problems before they arise and empower you with the information to plan. Today, we are honored to have David Lanier, an AARP Illinois volunteer, joining us. Welcome.
My name is David Lanier, and today I want to welcome you to a virtual event for AARP. AARP is a nonprofit, nonpartisan organization which is comprised of members in the 50-plus range. We currently have over 1.7 million members in the state of Illinois alone.
Today, we will be continuing our conversation with Steve Andersson. Steve is a partner in the government consulting practice Necritz Amdor Anderson Group, providing counsel and guidance to entities seeking to advocate in the Illinois state capitol. Prior to joining Necritz Amdor Anderson, he was a commissioner of human rights for the state of Illinois, appointed by Illinois Governor J.B. Pritzker. Steve is a retired member of the Illinois House of Representatives. He has also been a practicing lawyer since 1992 with a focus on elder and municipal law. He is licensed to practice in Illinois, the Seventh Circuit, and the United States Supreme Court. AARP Illinois welcomes back Steve to today's conversation on elder law and estate planning.
Thank you, Sonia. It's a pleasure to be here in the third of our sessions talking about elder law. Excuse me, I have a little cough today, so you may see that from time to time or hear that from time to time. Two things that I'd like to start with, and the first to me is the most important, and that is that I want you, if you take anything away from today, to remember it's going to be okay. Whether you've done some planning, but maybe not all the planning you hope to do, or even what your professional advisors have counseled you to do, or you've done none, or you've done everything. It's going to be okay. For the most part, the laws of the United States, all the various states, are set up mostly the way that you think that they ought to be, which is unique, right? A lot of us are cynical about law. But in the area of estate planning, kind of the default is if you do nothing, it approaches or it plays into that. They kind of assume, the legislatures kind of assume that you might do nothing, and they try to make sure that things fall the way, let's say, most families might intend. In other words, if you have 2 kids, it goes equally to 2 kids. If you have 3, it goes to 3. If you have no kids, it goes to other family members that are kind of on a direct line. So that's the thing I want you to take away today is don't worry, it's going to be okay. But we can do better than okay. And that's why we're talking today. The other thing that I want to tell you is that because we don't know exactly who's going to be listening to the broadcast, I'm not telling you specifically Illinois law. I'm telling you an amalgam, if you will, of most states' laws. So in a way, I'm telling you no states' laws. But that's so that this can apply generally to anybody who might be tuning in. But since I am an Illinois attorney, it is going to have a bias towards that. But most of what I'm going to say is applicable throughout the 50 states. So with that, I'm happy to be here and looking forward to the conversation.
Thank you, Steve. I'm confident today's conversation will be very insightful, as always. And if you would like to stay on top of the most recent and up-to-date information after this event, you can visit states.aarp.org/Illinois. So let's get started, Steve. I'm going to ask, this first question is one that was submitted by a viewer. We have properties, value approximately $40,000 each, and our will reads as all assets split among our 3 children. If we know one child wants to own either of the homes, would it be better to state that in our will?
So good question, and actually a complicated question right out of the gate. And I think you said 40, but I think maybe it was $400,000.
Yep, you're right.
For the estates?
Yes.
So great question. So normally if your will or your trust, doesn't matter which, says split everything equally, and you've got particular assets, and that could be property like this question asks about, like it sounds like they have maybe 2 homes, but they got 3 kids, and one of the children wants one of the homes. Well, if you don't do anything else, what'll typically happen is the properties that you have would probably be sold. And I don't mean like in a bad way, but usually in order to liquidate, to get all the money out so you can divide it equally, that means that what'll happen is you'll sell up to that 400,000 level and then divide by 3. Because what happens if that house is worth, or the 2 houses are worth 300,000 out of the 400? Well, that means if you give one of the houses to one child, the other 2 kids might not be getting an equal amount. So that can be difficult. Now, there's a couple of ways to handle that. One is, like the viewer said, would it be better to state that in our will? Yes. If you have a specific asset that you want to go to a specific child, then yes, put that right into the will. You can do that. But it still doesn't fix that underlying problem if you still want the kids to get an equal amount. That means you're going to have to balance out what's left. And a good professional will be able to help you do that if you have enough assets to balance it out. My only concern is, what if there aren't enough assets? What if the major asset was that one property? Then that becomes more difficult. But there's still a solution. And there's still a solution even if you don't say this in the will. So let's say they did nothing after this. The will just says split it equally. The family members can get together and they can say, look, son number 2 wants this house. Okay, we'll agree that he can buy that from the estate. And so by buying it, he's paying fair market value, of which he'll get back part of it because he's 1/3 of the estate. But he can buy out his interest. And by doing that, he can get the house. He might have a mortgage, and I'm just saying he because that was my example. He or she, they might have to get a mortgage for it, or maybe they give up all the other assets in the estate to balance it out. But that can be done after the fact too. So like I said, I'm going to keep repeating it. Don't worry. As long as people are getting along, if you got family members who are arguing, it's harder, but not impossible. But if the kids do get along, that sort of thing can be done either in the will, or if you don't get to that, it can even be done afterwards. So great question.
Always a way.
Always a way.
That's right. All right. So this next question, will my will or trust allow someone to help with my medical decisions?
Another good question. And this one distinguishes between wills and trusts and powers of attorney. So the quick answer is probably not. So your will or your trust are dealing with after you die, right? That's once you passed away. Well, you won't have any healthcare issues once you passed away, to be perfectly frank. The powers of attorney in most states are where that power resides. So you'll want to have a will or a trust, and we'll probably talk about that further, but you'll also want to have powers of attorney for healthcare and property. That's the way we refer to them in Illinois. Could be slightly different in other states, but the concept is the same. What you do is you fill out a document. It's also called a living will in some states, which is a confusing term because wills generally refer to what happens after you die. But a living will is about what happens when you're still alive. And you get to name people in that. And you can name one person, or you can name more than one. It can be anyone you choose. It doesn't have to be your spouse. It doesn't have to be your children. I mean, if you want it to be, it certainly can and should. But it's anyone that you want and trust. In fact, the way I would always say it when I was doing these for clients is I would say, if the person that you're putting down there, if that's a person that you trust, you don't have to worry about the fact that you're granting them a lot of power, because you do grant a lot of power when you sign a healthcare power of attorney or a financial power of attorney. But if you trust the person, you don't really have to worry about that. And then I would say, and if you don't trust the person, don't sign this document, because you shouldn't be giving that power, even if they're like entitled, like a child or something, but you don't fully trust. Don't do that. Give it to someone you trust.
Hence the name trust.
That's right.
Okay, our next question. With a trust, if I change the title on my property, do I still get my property tax senior discount? And is my name still on the property in that circumstance?
Good question. And this one probably does vary state by state. I will tell you that in Illinois, the answer is yes, you still get your senior discount, because there's the concept that these trusts they're kind of fictions, right? They're there for estate planning purposes, but everybody knows it's still you. You know, you're still the prime and really only beneficiary until after you pass away. And so in most cases, the answer is yes, you still get your discount, but your property title will show up slightly differently. It'll say, you know, the trust of John Doe or Jane Doe. Your name's still on it, but it has trust in front of it.
Okay, we have another question from YouTube. We had talked about putting our adult daughter on the title to our house in case of us needing to later go into a nursing home. Would a trust be better?
Good question. Interesting. So it probably neither will be very good, to be perfectly honest. When you put another person's name on your property, number one, you're giving them some power and control over that property, which might be fine with a daughter, but it also might be, you know, not advisable. But for purposes of qualifying for Medicaid, that's not taking your name off of the property. In other words, you're still fully vested in that property. It's still yours. It's still an asset. So that's not going to help you qualify or not qualify any better, for Medicaid. Similarly, I'm sorry, what was the second part of the question? The first part was putting the daughter's name on. Oh, would a trust be better? That's right. So would a trust be better? Probably not going to make a lot of difference in the Medicaid process, because again, Medicaid, even if it's in a trust, as long as it's not irrevocable, which we might talk about later, but if it's the normal kind of estate planning trust, they still consider it part of your assets as well. So either way, it's not going to make a huge difference to Medicaid in qualifying if you're looking to qualify. But do remember that of the many assets that you can't have and still qualify for Medicaid, one thing you can keep is your home. So that's an important and valuable asset.
Okay. Another question. I was listed in the will as a beneficiary of certain assets. Why didn't I inherit those assets?
There could be a lot of answers to that question. For example, one might be that there weren't enough assets at the time of death. In other words, someone may have owned a lot of assets at the time they made the will, but by the time they passed away, maybe they had to spend those assets, maybe even on a nursing home stay. And so there weren't any assets left. That could be one reason. No, another reason could be potentially that there was some issue with that particular item. In other words, if it wasn't cash, let's say it was a car, I don't know. Maybe the car just doesn't exist anymore. Maybe it broke down. And if they gave you a particular car, not just like a car, but like my 1964 Ford Mustang, which would be really cool, by the way. But if they gave you that and that car ceased to exist, that would be another reason why. But that's an interesting enough question where it's worth looking into if that's happened to you to find out what happened. And usually there's a probate estate, which means that if you have just a will, which means you can look, you can find out there's a final accounting which shows where everything went. And if you were listed and you were supposed to get something, you should be on there. So that's worth looking at.
Okay. We have another YouTube question. I live in a state that is not the same state where my designated trusted persons live. How do I assure there are no issues with differing state laws?
So I think what they're probably talking about is either an executor or maybe a trustee or possibly an agent under a power of attorney. Each one is different. But the good news is, for the most part, the laws of the various states recognize that happens, right? So they know that people move around. That's part of the beauty of our country, is that we can do that. And so for the most part, there's reciprocity between the states. So that as long as the power of attorney or the trust or the will was created in conformance with the law in the state you were in at that time, there should be no invalidity to it from the fact that you move or the fact that your trusted person moves. That's okay. But understand there's going to be a bit of an interpretation. So if you're still living in your home state and your trusted person lives in another state, they're going to have to abide by your state's rules and kind of vice versa. So for the most part, you're actually not going to notice a difference because most states' laws are similar on powers by trusted persons. But there can be nuance. So if that were to happen, what I'd probably do is just talk to a professional in that state, in the state that at that time matters. But for the most part, you're going to be okay. Remember, it's going to be okay.
It's always going to be okay. Thank you to all of our audience members for joining us today. And we'll move on to the next question. Hiring estate planning professionals is expensive. Is an estate planning professional the same as a lawyer? And can I prepare my own will and figure out a plan all by myself?
Sure. So most of the time, I consider estate planning professionals to be attorneys. I do. In a sense, they can use supportive personnel like tax preparers and accountants, because there are lots of times where maybe there are financial issues that are beyond the particular attorney. And so they're going to need to seek a team to be able to determine some of that. Sometimes if you've got someone who might need help, has Alzheimer's or a difficult end of life circumstance, that team might also include healthcare professionals so that everyone is planning around the best interests of that person. So for the most part, like I said, I think of the estate planning professionals as attorneys, but there can be lots of other people that are involved in that as well. Now, to the question of can I do it myself, a DIY, if you will, you can. My concern is that if your will is not pretty basic, now if it is, let's talk about basic and let's talk about not basic. So if your estate and your will or your trust is not basic, my concern is that you might miss a lot of nuances that an attorney or other estate planning professional might pick up, like some tax benefit that you're not aware of. So if your estate is somewhat complex, I would really urge you not to do the DIY, but you can. I mean, it's legal, you can do it, but I'm worried that you might not get it as right as you might otherwise. But again, remember, it's going to be okay. So even if you mess something up there, a lot of times the default laws of the state will help pick up what you might have missed. But I'd encourage you to use an estate planning professional. If you tell me, oh, come on, Steve, I've got the most basic stuff in the world. I own a house and a little bit of money in my retirement accounts, and that's basically it. Can you do that? Can you do a will? Yes, you can. You can find them online. Can you do powers of attorney? Yes, you can. In Illinois, in fact, Illinois' powers of attorneys are forms, that the state prepares. The legislature prepared a form document. So you can find them and you can use them. But even that, there are some things that aren't always included that a lot of estate planning professionals might tell you would be better if you add. For example, the powers of attorney for finance in Illinois do not anticipate and don't cover things like Medicaid applications. So sometimes there's some things that can be added. So bottom line is, can you do it? Yes. Do I advise you to do it? No. I think that it would be better to invest a little bit of money to save potentially a lot of money down the road. So
that's a great point. Great point. All right, our next question. I'm worried my family will contest my will. What can I do to prevent this from happening?
Good question. So we're gonna get in the Wayback Machine for a minute and go back about 100 years, because a lot of people will tell me this when they come in. They'll tell me, if I leave $1 to my family members, they can't contest my will, right? The answer is wrong. But there was a time, many 100 plus years ago, where that was a strategy, where you would leave a little bit of money, $1, some nominal amount, and then if they contested your will, the argument was they've lost all benefit to whatever you gave them, and that was all you were ever going to give them. So it was a strategy, but it doesn't work anymore. That's not true. Anyone can, any interested party, so either a relation or somebody who might be named in the will, can contest the will. It's not possible to avoid that. But what I would advise you to do is be as clear as you possibly can in your intentions, because the contest of the will usually means someone is arguing that you weren't competent at the time that you prepared that will, that it didn't reflect your intentions, or you didn't know what your intentions were. So the best thing you can do is document that. And so by going to an estate planning professional who has their own independent judgment, they can decide whether you're competent to be able to execute this will. I mean, when I do it, I ask a lot of questions to make sure that the client is oriented to time and place, and who their who their family members are, so that if called upon, if someone does challenge that will, I would be there. I would be able to testify and say, no, Mrs. Smith was great. She knew. I've had a long history with her. She knew her family. She knew what money she had. She knew who the president was. She knew all of these things. So document. I mean, you can even do videotapes. There are videotaped will executions now that you can do as well to show that you knew what you were doing. So best thing I can say is, while you can't stop somebody from contesting a will, you can document the way out of that problem by showing that you were competent and able to handle your own matters.
Which would be a point to not doing a DIY.
Exactly right. Because that's where, if you're worried that a family member is going to contest a will, don't do a DIY, because they might have an excellent chance at succeeding. I mean, maybe even something as simple as you didn't dot the right I or cross the right T in execution.
Right. Okay. Here's another question. I've never heard of this. What is a pour over will?
Sure. So a pour over will relates directly to if you have a trust. So if you just have a will, there won't be a pour over will. You just have a will. But if you have a trust, what that means is, in theory, you have put everything, all of your assets, into that trust. So they're not in your name anymore. But a pour over will catches anything that you might not have put into the trust, and it pours it over into the trust. So it's a very brief will. It's like 1 page, 2 pages maybe. And all it basically says is, anything that I had in my own name at the time of my death goes into my trust. So it pours over into it. And that can catch some very important things, because it sounds like I'm saying, oh, that's just little stuff, but it might not be. I mean, if you don't keep up with transferring things into your trust, what if you bought a new house? Well, maybe the house is not in the trust, or you didn't get around to deeding it into the trust. Or And I don't wish this upon anybody, but what if you passed away because of an accident and somebody else is liable for that accident? So now there could be a claim that you or your estate has against some other person, maybe the driver of another car or some other tragic circumstance. Well, that's personal to you. So it's not in your trust either. So let's say you get a big verdict on something like that. Not you, your family members, you had passed away at that point, but you received a big verdict. Well, if you don't have a pour over will, that means that money is just in your normal will, just going to be distributed differently from maybe how you intended it in your trust. So if your trust is the final word in how you want things distributed, you're going to want it to pour over into your trust. So that's a way of getting those last items that occur, even big ones, into your trust if you have a trust.
That's perfect. Okay, I am named as an executor of an estate. Now what? What does this mean?
So nothing to begin with. Sometimes you might not even know. Usually people tell someone if they're going to name them as an executor, but it doesn't always happen that way because life is not perfect. That's okay. So while the person is alive, you have no job and no duties and no responsibilities. An executor only takes over their function or takes on their function after the person passes away. So to begin with, you have no responsibilities. Now, I will say this, it is common for someone to name an executor and also name that person as a healthcare power of attorney or a financial power of attorney. In those cases, you might have some duties under those documents right away, helping to manage finances and things like that. But if you're just the executor, which does happen as well, then you have no duties until then. Once that happens, once someone passes away and now your duties kick in, the biggest job is to make sure the executor's biggest job is to make sure that all assets that were in your name at your death get distributed to whomever you intended for them to be distributed to in your will. But that's not as easy as it sounds. So the best thing I can advise is for the executor to go to an attorney and have them help you do that. Because if it involves probate, which it might, that means going to court, which is what the attorney is there for. And even if it doesn't, they can help you with the proper procedures and the proper documentation. You remember that question earlier about somebody not getting something even though they were named in the will? Well, going to that attorney is a way of making sure that that doesn't happen, that whoever was supposed to get whatever they were entitled to, that they get that. So it's important to talk to a professional even in that circumstance. And it won't cost you an arm and a leg. I mean, it's not that way. A lot of times, especially local attorneys, which I advise you to use in your own area, can be very reasonable in their pricing.
All right, such great information, and I thank you, Steve. But we are at the end of our time. Do you have any final comments before we close?
No, other than to say thank you. It's always a treat to do this. The questions that come from our listeners are fantastic. I mean, we could talk for an hour with these questions, even though we only have a half an hour. So my congratulations to the listeners for having some thoughtful or so many thoughtful questions, and allows us to really dig into the nuance by example. But I'm going to leave you with where I started. It's going to be okay. Thank you so much.
Thank you. Thank you to our guest, Steve Andersson, for joining us today. Thank you, AARP members, volunteers, and listeners for joining in this discussion. Continue to join for our virtual events with AARP Illinois. And if you're looking for more information from AARP, please Google our website at AARP Illinois or at states.aarp.org/Illinois. Thank you and have a wonderful day. This concludes our virtual event.